Hello, everyone. That thumbs up was for Ariana that she could cut the music. That was a longer song than we usually do, and it was never ending. Anyway, welcome. Hello. My name is Kate Rubin. My pronouns are she, her, and I'm the organizing director of Seattle. Welcome to our June Building Tenant Power Workshop, Asserting Your Civil Rights. I am joined tonight by our operations director, Tanya Moore, our workshop coordinator, Ariana Laureano, who isn't feeling well and will be off screen, but she's still here doing tech, and our awesome guest speakers, Michael Chin and Tess Honan from the Seattle Office for Civil Rights, and Devin Glaser with the Tenant Law Center. I am going to start us off with a land acknowledgement. We are on the land of the Coast Salish peoples. I would like to recognize that we are occupying the traditional land of the first people of Seattle, the Duwamish people, past and present, and honor with gratitude the land itself and the Duwamish tribe. We encourage each of you to sign the petition for federal recognition of the Duwamish tribe, and if you're able, visit the Longhouse and pay rent to the Duwamish. You can learn more from Real Rent Duwamish. We'll include a link for them in our resource guide that we'll send out after the presentation. Our resource guide also contains contact information for the Seattle Office for Civil Rights, the Renting in Seattle Helpline, the Seattle Department of Construction Inspections, also known as SDCI. They're responsible for enforcing landlord-tenant laws, and it also contains a bunch of other helpful information. I want to briefly review our community expectations for this evening before we get started. Participants and attendees are to treat each other with respect and understanding. Please remain muted while guest speakers are presenting. There will be a Q&A portion after, during which you're welcome to unmute, but please save your questions until then or use the chat function. And also note that the workshop is being recorded and will be posted later. So if you're concerned about privacy, you're welcome to turn off your camera or change the name displayed on the screen. To do this, go to participants, right-click on your name, tap rename, and type in the name by which you'd like to be addressed. Okay, we encourage you to get more involved with Seattle. We're seeking board members, volunteer app developers, table volunteers, flyer friends to help get the word out, and people interested in developing their skills as part of a tenant leadership team. We would love to help you organize your building. It's okay if you've never been involved in organizing before. We're here to help. We can help you with outreach to your neighbors, agenda planning, relationship building, crafting demands, strategizing, developing a tenant association, and more. We also have some funds to the Seattle Office of Equitable Development designated to provide stipends to renters who are taking an active role in organizing. So please reach out to me. My email address is kate@bseattle.com. And I'm going to share a few upcoming events and then we'll jump right into it. Saturday, June 25th, 10 a.m. to 8 p.m. at Seattle Center Mural Amphitheater. Taking Black Pride presents Seachella, a pride celebration by and for BIPOC, trans, and queer community. This event is free for the BIPOC, trans, and queer community. To honor the intention of the space, they ask that allies pay a sliding scale donation of $10 to $50. You can learn more by following Taking Black Pride on Instagram. Thursday, June 30th from 4 to 7 p.m. at Life on Mars. It's the Tech for Housing June Outdoor Happy Hour. Whether you are an existing member or just a bit curious and wanting to learn more about the group and what opportunities there are to get involved, Tech for Housing welcomes you to come and help rebuild this community of tech workers who work towards making the Seattle area a place where everyone can live. Friday, July 8th from 6 to 9 p.m. at the AIDS Memorial Pathway, AMP in Capitol Hill. Come celebrate the efforts that House Our Neighbors Coalition put into education about social housing and signature gathering for Initiative 135 and help us launch our Get Out the Vote efforts. We'll drop the link to register in the chat. Also, the event organizers could use some help with the setup starting at 3 p.m. and then the teardown from 9 to 10. So if you're able, please fill out the volunteer form and we'll drop a link for that in the chat too. Saturday, July 9th from noon to 3 p.m. at Thornton Place Apartments Community Room is the annual meeting for Share the City's Action Fund and Share the City's Community Education. Come hear about Seattle's comp plan, rezoning Seattle, how to engage with youth and neighbors, and how to engage in land use decisions. Full disclosure, I'm on the board for Share the City's Community Education. One of my favorite things about Share the Cities is that you aren't expected to be an expert in policy or land use. They work to make complex, sometimes tedious issues that deeply impact our communities more accessible and sometimes even fun to folks who might not have even engaged otherwise. Both the Action Fund and Community Education could use some additional board members. This is a great place to get to know folks. Let's see, Wednesday, July 13th from 3 to 4:45 p.m. is a Solid Ground Rent Smart Tenant Rights webinar. I can't pay full rent. What are my options? What's the best way to proceed? Are you unable to make rent this month? Curious about what you can do? Join Solid Ground tenant counselors to better understand what rights you have if you aren't able to make rent and what comes next. A visiting attorney from the Tenant Law Center will be on hand to answer questions. Wednesday, July 20th from 12:30 to 2:30 at the Capitol Hill Library in the Capitol Hill Meeting Room is our next Elder Renter Council meeting. East Seattle is facilitating a renter council for elder community members to work together to strategize and fight for renter protections that they feel are important to their communities, provide peer-to-peer support for folks organizing in their building, grow renter power, build community amongst Seattle area seniors. I see a couple of folks from the first meeting have joined us tonight, and newcomers are always welcome. Renters of all ages are invited. However, the meetings are centered around renters ages 55 plus. This will be our second meeting, and we'll be focused on creating shared values, goals, and drafting our mission statement. We meet on the third Wednesday of every month. Wednesday, July 27th at 6 p.m. is B Seattle's next Building Tenant Power Workshop, Demystifying Section 8. In this workshop, we'll take a dive through the intricacies of Section 8 housing vouchers. What is Section 8? How does the process of obtaining a voucher work? And how is Seattle different from other cities? Organizers from B Seattle will be joined by guest speakers who know the ropes of Section 8 and are ready to help guide you through the steps it takes to obtain a voucher. Please note this is an educational workshop only. B Seattle cannot issue Section 8 vouchers or make direct referrals. And then lastly, Tuesday, August 2nd at 6 p.m. at the Burien Community Center. It's the Tenants Union 45th anniversary kickoff, a community celebration. Come to celebrate the accomplishments of the Tenants Union and help them to further develop their base. This event will include food, cultural performances, and an update on their work from the leadership of the Tenants Union. Now, before we can talk about our rights as they stand today, we should consider how we obtain these rights and why they have to exist in law. I'm going to pass the mic to Tanya, who's going to share a bit about Seattle's civil rights history. Take it away, Tanya.
All right. Thank you guys for joining us. Thank you, everyone. So for most of its history, Seattle has and was a sharply segregated city, as committed to white supremacy as any location in America. People of color were excluded from most jobs, neighborhoods, and schools, stores, restaurants, hotels, and other commercial establishments, even hospitals. As in other Western states, the system of severe racial discrimination in Seattle targeted not just the Black community, but also Indigenous Americans, Asian Americans, Pacific Islanders, people of Mexican ancestry, and the Jewish community. While the realm of housing within the realm of housing, racially restrictive covenants categorize land as only inhabitable by white families. These covenants often regulated people of color to only being allowed on the property if they were gainfully employed servants to the white occupants. These laws were in effect the Western manifestation of Jim Crow laws, and they continued here in Seattle until around 1949, when the city council began refusing new plats of land in our city if they contained racial restrictions. It's hard to imagine some of the language that was used, as it's not as commonplace today, especially up in the Pacific Northwest. So it's important to give an example. Some of the more common deed languages that didn't include direct slurs were as follows, quote, "No person of any race other than the white or Caucasian race shall use or occupy any building or any lot, except that this covenant shall not prevent occupancy by domestic servants of a different race domiciled with an owner or tenant. This language and language like this governed deeds in 15 to 20,000 properties throughout the King County area. The map to the right shows where we know there were racially restrictive covenants. This is from an interactive tool where you can isolate types of racial covenants the city has had over time. We're going to drop the link in the chat if you are really in the mood to dive down that rabbit hole right now, or after this workshop. You can follow, drink the bottle and follow the rabbit hole down. The red circles indicate restrictions recorded in property deeds. Yellow circles indicate that restrictions were advertised in newspapers and enforced by realtors, but deed records have not yet been found in a partial search. We're going to also put a link in the chat to an in-depth breakdown of maps of Seattle's segregation story. This is the racial makeup of Seattle in 1950, with the white population on the left, the Black population in the middle, and the other races on the right. The Census Bureau didn't collect a lot of information at that time to really understand the racial makeup of the population included in other races. As you can see, redlining restricted Black people and other people of color to only a tiny portion of the city. On June 12, 1953, when the Civic Unity Committee wrote to the City Council requesting the city not accept plats with restrictive covenants, Councilman Mitchell responded by agreeing with the policy and stating that the entire council is in agreement. Once the City Council began refusing plats with racially restrictive covenants, real estate agents operating under unwritten rules would not show houses in all white neighborhoods to people of color. On the rare occasion that a non-white buyer was shown a house in an all white neighborhood, the actual purchasing in the home became extremely complex. And we still see some of this today. As someone who does have a real estate license, I'll throw this in here as I was thinking about it, especially when it comes to appraisals. Owners of homes that are all white, their houses are appraised for more than individuals who are trying to sell their home if they are of color. The state's Omnibus Civil Rights Act of 1957 was a narrowly defined attempt to end discrimination in housing, but it focused only on purchases secured with government loans. Attempts at the state level to pass broad anti-discrimination and housing laws were vigorously opposed in the late 1950s and early 60s by apartment building operators and real estate representatives. Those special interest groups charged that fair housing laws would infringe on the constitutional property rights, were dictatorial, confiscatory, and would lead to evasion and disrespect for the law. Some small voluntary efforts to integrate neighborhoods were in place by the end of the 50s. The Greater Seattle Housing Council was formed in 1956 to encourage dialogue between proponents of open housing and the real estate industry. Other groups, such as Christian Friends for Racial Equity, urged the Seattle City Council to pass an ordinance prohibiting racial discrimination in any type of housing. The Central Brokers Association was formed in 1961 to find housing for minority families in many parts of Seattle. By 1959, there was a time Robert L. Jones and his wife attempted to buy a house outside of the central area. The owners, John O'Mara and his wife, refused to sell to the Jones family because of their color. Jones appealed to the Washington State Board Against Discrimination, but the board upheld the Joneses' appeal and declared that the O'Maras' refusal to sell the house to the Jones family because of their color was an unfair practice. The O'Maras weren't happy with that decision, so they appealed that decision to the King County Superior Court, where their decision not to sell was upheld. The case went to the Washington State Supreme Court in O'Mara versus Washington State Board Against Discrimination, which ruled on a 5-4 vote in favor of the O'Maras. In February of 1962, the O'Mara family continued to, sorry, that should say actually, yeah, the O'Meara family appealed to the United States Supreme Court, which denied their petition to review the case because it just kept coming back. Local events such as the Jones-O'Meara case and awareness of the burgeoning national civil rights movement inspired fair housing activists in Seattle to start pushing for open housing legislation. Late in 1961, the Seattle branch of the NAACP proposed that the city pass an ordinance prohibiting discrimination in housing. A public hearing on the idea was held in 1961 in December, and Seattle's Corporation Counsel, A.C. Van Solen, stated that the proposed ordinance would have dubious legal validity and would be problematic to enforce. So the city council decided and declined not to take action. An ordinance establishing the Seattle Human Rights Commission was passed on July 17th of 1963, in part because of organized protests and other acts of nonviolent civil disobedience related to employment and housing discrimination issues. Not long after they were established, the commission drafted an open housing ordinance, providing for criminal penalties for acts of housing discrimination on the basis of race, ethnic origin, or creed. The commission recommended that the ordinance contain an emergency clause that would be put into effect immediately upon passage and prohibit the possibility that the ordinance, could be referred to a vote by the public. At a city council committee of the whole meeting on October 25th, 1963, the decision was made to refer the issue to the voters and place the ordinance on the ballot. Those opposing the open housing legislation advertised heavily with slogans referencing personal freedom and forced housing. The advertisements urged voters to examine human rights and property rights and to vote no in order not to lose family freedom. Sound familiar? Proponents of open housing legislation sponsored marches, rallies, and educational meetings. A rally 2 days before the vote was held at Westlake Plaza with over 1,500 attendees. Those endorsing the ordinance at the rally included the council planning affiliates, representing health and welfare agencies, the Puget Sound Cooperative League, composed of group health cooperatives, King County schools, and many church and community groups. The open housing legislation went before the voters on March 10th of 1964 and was defeated by more than a 2-to-1 margin. So 115,627 opposed to 54,448 in favor. As time went on that year, with the signing of the Civil Rights Act on July 2nd of 64 and the Voting Rights Act on August 6th of 65, slowly changing attitudes towards segregation in housing, as well as increasing fear that racial tensions could explode in Seattle, served to trigger the passage, finally, of an open housing ordinance in 1968. On April 19th of 1968, 3 weeks after the assassination of Martin Luther King Jr., the City Council unanimously passed Ordinance 96619, quote, defining and prohibiting unfair housing practices in the sale and offering for sale, and in the rental and offering for rent, and in finance of housing accommodations, and defining offenses and prescribing penalties, and declaring an emergency therefore, end quote. The ordinance had been sponsored by 6 of the 9 council members, but the chief architect was first-term council member Sam Smith, who was the first African-American to sit on the council. The open housing legislation passed in 68 was amended in 1975 to include prohibitions against discrimination based on sex, marital status, sexual orientation, and political ideology, and in 1979 to include age and parental status. In 1986, creed and disability were added as prohibitions on discrimination, and in 1999, gender identity was added. So now that we've covered a little bit about the fight that it took to earn these housing-based civil rights, Kate's going to introduce our amazing guest speakers for the night.
Thank you, Tanya. I am so delighted to introduce our first set of speakers, Michael Chin and Tess Honan with the Seattle Office for Civil Rights. Mike is responsible for enforcing Seattle's civil rights and anti-discrimination laws in employment, housing, public accommodations, and contracting. Under his leadership, Mike and his team have shifted to a more preventative and proactive community-centered approach to civil rights enforcement by providing training and technical assistance, conducting fair housing and employment testing, offering restorative mediation, engaging in outreach and public engagement, case investigations, and coordinating the citywide Title VI program. Mike is a certified mediator with the Washington Mediation Association, a member of the citywide RSJI Core Team 4, and a former Seattle Office for Civil Rights Change Team member. Mike received his Juris Doctorate degree from Gonzaga University School of Law and his master's degree in business administration from Gonzaga University in 2006. Born in Moscow, Idaho, Mike's father is an immigrant from Jamaica, and his mother is a second-generation Chinese American. Mike enjoys traveling, food, learning about cultures, exercising, practicing mindfulness, spending time with family, and reading. Mike lives with his partner. Mike, I'm going to apologize if I get this name wrong, and please feel free to unmute and correct me because I'm reading from a script. German Gornalis. Pretty close.
Yes, very close. Very good.
Okay. And with their Chow Golden Retriever mix, let me try this one too, Osito, on Beacon Hill in Seattle. Oh, we're neighbors. I just moved to Beacon Hill. I had my first night here 2 nights ago. And Tess is from sunny Phoenix, Arizona, but has learned to love these Seattle rainy days. Wow, Tess, you must be really trying to accommodate our January. She is a double alum of Seattle University, where she received a BA in Humanities and Public Affairs, a master's in nonprofit leadership, and a certificate in fundraising. Tess joined the Seattle Office for Civil Rights in September 2021 as a community engagement specialist, implementing proactive and strategic outreach strategies and subject matter expertise on Seattle's non-discrimination laws. Prior to this role, she worked as the Community Partnership Manager at the Center for Community Engagement at Seattle University. In her free time, Tess enjoys baking bread, reading, walking, and doing yoga. Together, they've come to give us a presentation on civil rights and how their office works to enforce them. Take it away.
Well, thank you for that welcome. I'm very happy to be here. Can I share should I share my screen, show the PowerPoint? Is everyone seeing that?
Good.
Looks good, yes.
But we want to see, sorry if this is clunky. I'm going to get to presentation view.
It should be the icon next. Oh, it was there.
So sorry.
In the very bottom is a picture of like a podium, basically. Normally that's there. Yeah, you get 50%. I think that's it.
Yes. I wonder if there's a way to see my notes on here too.
Tess, if you want, I can share my screen. You want
Can
to
you
do
do that, Mike?
Sure.
Yeah.
Yeah. I can do that.
That way I can look at my notes.
Sure.
Well, while Mike pulls that up, I can get started. So Mike and I are from the Seattle Office for Civil Rights. My name is Tess Honan, and I use she, her pronouns. I am the community engagement specialist in our office. And I'm joined today by Mike, who is Mike, what is your title again?
The Civil Rights Enforcement Director.
Director, yes. And we will be co-presenting this Tenants' Rights 101. So our hope for this presentation today is that you will learn about illegal housing discrimination under the law and to provide a really basic overview of Seattle's laws. This session was designed specifically for tenants and to expand on that basic understanding of fair housing laws. If any questions come up throughout the presentation, feel free to use the chat function, or you can just say it out loud too, or raise your hand. We'll do our best to monitor the chat as we go, but we want to make this as interesting and interactive as possible. that's all my notes. Yeah, next slide. So we just got a really great overview of the history of civil rights and of housing law in Seattle, which was super helpful. We're specifically going to be talking about fair housing today, which was that in 1968, Congress had passed the Federal Fair Housing Act to eliminate individual, institutional, and structural barriers to ensure equal access across housing across the U.S. The objective of this important legislation was to prohibit individual acts of discrimination, break down neighborhood segregation and the concentration of poverty, and to eliminate institutional acts of discrimination. So fair housing is the right of everyone to have equitable access to housing and housing services, and is inclusive of rental and sales, mortgage appraisals, insurance, and advertising. So under local, state, and federal laws, there are all laws to govern housing discrimination. And that's what our agency, the Seattle Office for Civil Rights, SOCR, does. However, Seattle's laws are particularly more protective than our state and federal laws. Okay, next slide. So today we'll be talking about a couple different types of discrimination. These are some of the common types: different treatment, disparate impact, reasonable accommodation or modification, harassment, and retaliation. So we'll be getting a bit more into these types of discrimination as we go. All right, next slide. So protected classes are protected classes are the characteristics of people that are covered by discrimination laws. So if a landlord engages in prohibited activities based on one or more of your protected classes, then they would be violating your fair housing rights. So these can look a little different in discrimination law. So we have some, I'll just read the protected classes, and then Mike is going to give some examples of how this might show up. So Seattle has one of the most protected classes in all of the United States, I think next to New York City. And we have race, color, national origin, citizenship, immigration status, religion, sex, disability, familial status, marital status, sexual orientation, gender identity, veteran/military status, age, ancestry, housing choice voucher, subsidy, alternative source of income, political ideology, and creed.
Great, thanks, Tess. And so in terms of examples, some things that you should also notice around protected classes is that you can be members of multiple protected classes. So you could be discriminated based on sex, sexual orientation, gender identity, disability, all the different protected classes. And since we're all members of multiple protected classes, we will investigate each of those issues separately and what it means. I think in the previous slide that Tess shared around different treatment, an example of that would be a person who's treated differently because of their protected class. So for example, if you have a landlord who doesn't do maintenance requests, doesn't fulfill your maintenance request, but fulfills it for everyone else who's non-white or white, then that could be discrimination based on race. When you talk about disparate impact, it's where you have a neutral policy or practice that has a discriminatory impact on a protected class. An example of this would be if your landlord's application says you must have a driver's license in order to apply for housing. That has a discriminatory impact on people with disabilities, possibly national origin, immigration status, and others who may not have access to a driver's license. Those are some examples of how discrimination may play out and protected classes. Reasonable accommodation, Tess is going to talk a little bit more about that, but reasonable accommodation and modification is an example of where an individual can be treated differently legally, right? A person with a disability has a disability-related need for an accommodation or modification is an example where a housing provider has to provide access to that individual so they can enjoy their dwelling. Harassment and retaliation are other forms of discrimination, and harassment would be when someone unwelcome behavior and that unwelcome behavior is creating a hostile living environment, or quid pro quo, and that's based on a protected class. And retaliation is when someone is asserting their fair housing rights. And because they're asserting their fair housing rights, an example could be requesting for a service animal, or saying, hey, I believe that I'm being harassed in the work in housing, and later the housing provider evicting you because you had made a complaint to our office. So there's just some examples of that. Some other things to also note from this slide is association with someone with a protected class. So if you are a person who is associated, so for example, if your partner is of a different race and your landlord is targeting your partner because of their race, and because you're associated, you have a right to file a complaint because of you are being treated as an entity discrimination. You're being subject to discrimination. And even though criminal history is not a protected class, we're going to talk a little bit later in our presentation about the fair chance housing protections that are very unique to Seattle, and is actually one of the most expansive and protective laws we have in the country. Tess?
Great. Thank you, Mike. I think this is a good chance to pause. There's a lot of information under protected classes, and I find the language to be a little legally. So does anyone have any questions so far? And you can also use the chat if that's. Credit checks disproportionately impact and may exclude out some protected classes. That's something we as renter advocates could consider fighting for going forward. From Katie.
Yeah, and that is probably the number one topic that we receive of concerns from tenants around feeling like they're being pushed out or excluded is credit history. And we know that credit history has an effect based on a lot of protected classes. And so even though it's hard to prove disparate impact, they do have an impact on protected classes. Unfortunately, it's not currently a protection, but I know that a lot of organizations such as yourself are really trying to push forward to really put bans on landlords using credit history, because we know that not having a good credit history doesn't necessarily mean you are a bad tenant, right? We know that there is not any correlation or any sort of information that shows that. That's a great comment. Thank you.
We got another comment from Dee saying rejection of portable screening documents is a monetary barrier when one is paying for the same credit and background check over and over.
Yeah, I know that in the past, City Council has looked at legislation to have kind of a universal sort of application process. I don't think it actually got a lot of traction, but it is something that a lot of the challenge, I think, with the sort of universal credit checks or the background checks is that there's so many different providers of this and different landlords who use different forms of what they look at. And so I know that having a universal would help tenants not have to pay the $50 or $60 per application fee to do the credit check. So that is definitely something. It's not covered under fair housing or what we're here to discuss, but it are some of the big issues that we definitely hear about. Thank you for those comments.
All right, let's go on to the next slide then. So we're going to talk a little bit about reasonable accommodations and modifications, which start with whether a person has a disability. And next slide. So each agency has a different definition of disability. We follow this one: the sensory, mental, or physical impairment, common or uncommon disabilities, or mitigated or unmitigated. And so fair housing requires equal access to housing. Seattle also has some of the nation's broadest protections, but over 50% of our housing discrimination complaints that we see are related to a person's disability, most of which are because of failure to grant a reasonable accommodation or modification. So housing providers cannot ask about the nature or the severity of a person's disability. And then I think, Mike, next slide. So the accommodation and modification process is looks like this, but I think first we'll talk about the difference between the two. So reasonable accommodation is asking for a change to a policy, procedure, rule, or practice that may be necessary for a person with a disability to use and enjoy the dwelling. This could look like accessible parking, rental documents in larger font print, transfer requests, where reasonable modification is a change to physical structure that may be in the unit or common areas for a person with a disability to use and enjoy the dwelling. And an example of reasonable modification might be widening a doorway, installing grab bars, lowering a closet rod. And so a common question that comes up is who pays for reasonable accommodation and modifications. So accommodations are typically paid for by the housing provider, where modifications are typically paid for by the tenant. If charges are made to the interior or the unit of the unit or common area, the housing provider may require funds to put into an escrow account to cover restoration to the original condition if it would affect the marketability of the dwelling. And then for federally funded properties, the housing provider is typically responsible for the cost. And so another question that often comes up is why housing providers may deny a reasonable accommodation or modification request. And that can happen for a few reasons, being undue financial and administrative burden. If the expenses for the reasonable accommodation or modification are too difficult or too great, then that may be a reason for that to be denied. If there is a direct threat, so if significant risk of substantial harm to the health and safety of individuals and others, actual threat, not a perceived threat, not like stereotyping. Fundamental alteration of services. So if the change is so significant that it changes the nature of the goods, services, facilities, privileges, and advantages offered. But a key piece to this you can see in the flow chart of how to request an accommodation and modification is that it can be written or verbal when the request is made. I think that the key piece is the interactive dialogue. So once the request is made, there must be ongoing conversation about the requested accommodation. And then a landlord may ask for documentation, and that would be a third party verifying the disability or accommodation if necessary. And we'll see on the next slide about the requesting verification. I think I covered everything on that last slide. Yeah. So this is the verification process, answering some questions about, so when can a verification be requested? When the disability is not known or obvious, when there is a need for accommodation, when the need for accommodation is not known or obvious. And then landlords can request verification of disability or verification of disability related need for accommodation. And then those verifications can only be or can be provided by qualified third party with the knowledge of the disability and or need for disability. See, there's a question in the chat. Okay, so Devin says, similarly to the Stay Healthy Coalition is asking cities to ban the request for social security numbers as this disproportionately impacts people based on immigration status. So a comment, Devin, and then Sarah says, I believe that the Federal Fair Housing Act does not apply to owner-occupied buildings with 4 or fewer units, single-family homes rented without a broker, etc. Are there local laws that broaden fair housing to apply to all landlords, or are there still exceptions under local laws?
Yeah. So I'll answer the last question first, and so that is correct. Under the Washington law against discrimination, so statewide protections and also protections of the Seattle Open Housing Ordinance is 1 or more units. And so the fair housing protections includes 1 or more units. Under the federal law, it has what is called the exemption that has to be 4 or more, then the federal law does not apply. But because our law is much broader and more protective, we have 18 or about 16 more protected classes than under the federal law. And we have much more protections, and the definition of disability is much broader than under the federal definition. The protections are much stronger here in Seattle. And then I think the first question that came up was a comment, correct?
Mhm.
And that comment, can you remind me, Tess, what that comment was?
Yes, it was from Devin regarding social security numbers that disproportionately impact people based on immigration status.
Yeah, and that's actually a really good point. Similarly to when I had given the example of driver's license requirement, right? What would be that requirement has a disparate impact. Social Security also can have an impact based on immigration status and also citizenship. Those are 2 new protected classes under our ordinance that just passed at the end of last year. And so in December, I think December 26th or December 28th, I believe, where it was signed into law. And so those are protections for not just in the city of Seattle, but also statewide. Those have been on the books. The thing is that the housing provider is going to have to be able to show that what is the need to have a social security number. A lot of housing providers will request a social security number in order to do a credit check, right? That's usually the most common use of a social security, date of birth, first and last name is usually what's requested in a credit check. And so that is what most landlords will be using that. But if it's a criteria of, hey, we will not rent to someone if they don't have a social security, that would be discrimination based on disparate impact, a policy that has a discriminatory impact based on protected classes. So those are great comments. Thank you so much for adding those.
Yeah, we have a couple other questions too. So from Devin, why aren't housing providers asked to cover costs of modifications if they can't show that the alteration could be cost prohibitive? Shouldn't the default assumption be that the housing provider is better able to afford a minor modification than a renter?
That's a great question too, because under, for example, the Seattle Housing Authority, if there's any modification that's needed in a project-based housing choice, Section 8 building, those are going to be paid for by the housing provider or by the public housing authority. However, in modifications, the common law, I think case law has basically said any accommodations is basically the responsibility, the cost falls on the housing provider or landlord. If it's a modification though, anything changes inside the unit, that would be something that is required by the tenant. And so that's just following case law around that. There hasn't been any sort of legislation that has changed that. However, any modifications in the common space. So for example, if you are living in a big building and in the and there is a tenant who has a physical disability and needs a ramp put in place in the common space, like entrance into the building, that would actually be responsibility for the landlord to pay for those modifications. And that's kind of the distinguishing the two of who pays.
Yeah, we're getting a lot of great questions in the chat. So 2 more. So are there penalties for not granting / stonewalling and accommodation request? And this is a question from Dolores.
Yeah, so that's kind of where our office comes into play. So if a housing provider or landlord is not granting a reasonable accommodation or modification for a person with a disability and disability-related need for the accommodation, could be a service animal, could be parking, things like that, then individuals have a right to file a discrimination complaint with our office. We investigate it as neutral investigators, and then we would then determine whether or not that is indeed needed for that tenant, and that housing provider would then be responsible for paying whatever the reasonable accommodation, any out-of-pocket expenses, monetary, and any other penalties associated with that. And that's what our office would be doing. Very similar with HUD and the Washington State Human Rights Commission would do.
And then from Diane, if a reasonable accommodation is dragged out causing further harm to the tenant, what can a tenant do?
Yeah. So there's what is called where if it's a undue delay that a housing provider is dragging their feet, not being responsive to the reasonable accommodation, that in itself is what we would call a constructive denial. And so in that situation, it is basically effectively denying the person a reasonable accommodation. And at that point, you should definitely contact our office to file a complaint, and we would then figure out ways to address these particular issues with the landlord.
And then I see the follow-up question from Jay McKay. Did that last answer your question? You can just put that in the chat. I think we can move forward, and then Jay McKay, you can put in the, oh, no, okay. So we'll just go through this one too, and then we'll move forward. So I have from Jay McKay, I have approved doctors and management reasonable accommodation over 6 months now after no action, including no questions answered, reached out to Housing Justice Project. More than a month since the building management has completely ignored the attorney. No idea how to go forward.
Yeah, so that would be a prime example of contacting our office, talking to our intake investigator, and then seeing what actions we can do. So I think there's a slide later down in the road, later about how to file a complaint. Mm-hmm. And so we'll explain that process to everyone so that Jamie and other folks know kind of what is our process and timeline of how we would be investigating those cases.
Yeah, great. All right, next slide. So something we see a lot of also is service animals. So fair housing law requires reasonable accommodation for people with disabilities. One of those accommodations is allowing the tenant to have a service animal. So service animals in Seattle are broadly defined as assistant animals, companion animals, emotional support animals, etc. All service animals are under service animals under Seattle's laws. There is no requirement for training from a school. The owner can provide training if they choose to, but that is not a requirement. There are no requirements for certification of service animals because there is no state/national standard for certification. Housing providers can request a verification from a qualified third party. This may be a doctor, but can also be someone else who does not have a personal relationship to the tenant. Housing providers must waive pet policies. So you cannot be denied housing because there are no pet policies that would not apply to service animals. You would not need to pay pet deposits, pet rent, or breed restrictions. And housing providers can have a service animal addendum, and service animals are subject to the same lease rules as pets. So if there's any damage incurred, it would be on the owner to take care of that. All right, next slide. So now we're going to talk about first in time, which is that law that Mike had mentioned earlier. One of the, oh wait, we haven't gotten to this. So first in time is kind of how it sounds. First in the criteria, it's a law that uses the criteria used to screen applicants and minimum standard for this is everything that needs to be in a notice requirement for landlords. So the criteria they're screening with, minimum standard, person needs to meet to move forward with an application process, all information or documentation needed for the landlord to determine if the tenant applicant meets the criteria, written notice of how to request additional time to complete an application for meaningful access or reasonable accommodation for disability, and if a unit is set aside for vulnerable populations. So the first in time requires that all of this is written in a notice from the landlord. And then the next slide. The landlords must note the time and date that each application is submitted and screen those applications in chronological order. Then offer tenancy to the first qualified applicant that meets all the criteria. So after that, once they they must provide the applicant with 48 hours to accept. If the applicant does not accept, then they move to the next in chronological order. So an application is considered complete when all of the landlords listed the notice is all of that information is provided. If more information is needed, the application is not automatically considered incomplete, but landlords must give the applicant 72 hours to provide that additional information. And if not provided in 72 hours, then the application is considered incomplete and they will move to the next tenant. Yeah. Any questions about first in time?
I just want to just make a quick comment about first in time. First in time was passed recently, about 4 years ago. And the reason for this law was to eliminate or mitigate the effects of biases. And so what this law prevents landlords to do, not saying that they don't do it, but what it prevents them from doing is choosing who they like, right? And so kind of that association bias that sometimes plays out where, hey, a landlord may say, you know, I really like this person over this person, and using their biases to select people for that particular unit. What First in Time tries to do is to eliminate that implicit bias that everyone holds and say, hey, you should consider the first person in line before you consider the second person. And you need to make sure that it's clear that you have the criteria available for everybody to know what is required for that person to be considered for the tenancy. So it's full transparency, is to address biases and to actually have a process in place to make sure that people all have an equal chance of renting that particular unit.
I also just saw a comment from Ariel in the chat, and unfortunately, Mike and I are not legally allowed to talk about open complaints. So if you have follow-up questions for SOCR, please reach out to our email, right, Mike, to the intake?
Yeah, and if you have an open case and you still have questions, reach out to your investigator. Or if you're working with the intake investigator, reach out to them and ask those questions. For us, the information we're providing, we don't have a lot of context to what individual complaints or concerns are, but please do reach out to our office and follow up with them if you have any further questions.
Unresponsive, unfortunately, but I do appreciate.
Yeah. And Ariel, feel free to reach out to me. My email is available at the very end, so I'm happy to reach out to you directly, Ariel, if you have concerns about customer service or not getting your answers.
I've had a pretty bad experience, but yeah, michael.chin@seattle.gov, is that right?
It's mike.chin@seattle.gov. Yeah, right. For sure. Please do reach out to me.
Thank you.
Yeah.
All right, next slide. Okay, so alternative source of income and subsidies. So people with Section 8 vouchers have protections under Seattle laws for more than 20 years. So in 2018, this protection was expanded to cover alternative sources of income and other subsidies. Also, just a note, Section 8 now is often referred to as housing choice vouchers. So we're talking about the same thing there. Alternative source of income is verifiable income that is not a form of employment. Subsidies may include short or long-term subsidies from the government, nonprofit, or other assistance programs. And the overview is that it requires landlords to cooperate with subsidy programs, requires landlords to accept written pledges of payments from subsidy programs to settle bills, sets income screening requirements, and prohibits preferred employer programs. Now, this is that expansive law that Mike had referred to earlier, Fair Chance Housing and Eviction Records Ordinance. So this law, do you go to the next slide? This law covers arrest records, conviction records, and criminal history. Criminal history includes pending charges, juvenile records, deferred sentences, and dismissals. So in advertising, housing providers from it prohibits housing providers from excluding applicants with criminal history. So for example, like a Craigslist ad for a unit cannot say no criminal history allowed. Notice, it requires housing providers to provide a notice of the law on applications. In screening, it prohibits people from requiring disclosure, inquiring, or using criminal history information, except for the sex offender registry, and then that has a juvenile exemption. For the sex offender registry, if a housing provider takes adverse action against an applicant with a criminal history, they must have a legitimate business reason for doing so. And then it also, fair chance housing also incorporates retaliation protections. So the housing provider may take adverse action against a prospective adult occupant or an adult tenant or an adult member of the household if the conviction occurred when the person was an adult, and only if there is a legitimate business reason. So the adverse action might be denying tenancy, eviction, failing or refusing to add an individual to the lease, or applying different terms and conditions of that lease. So legitimate business reasons would be required to, you would be required to demonstrate a connection between the policy or practice and the resident's safety and or protecting property, and to consider the following factors, which are the nature and severity, the age of the person at the time of conviction, number and type, the evidence of good tenant history, time since date of conviction, and supplemental information. Mike, do you have anything to add to that?
Nope, I'm good.
Okay.
There might be some questions that I'm happy to answer.
Yeah, so I'm not sure if I already read this or if I read it in my head, but Kate said, comment only, the first in time law is really helpful protection that I would love to see statewide. We've seen a lot of issues with this outside of Seattle. And then a question from Devin, is there a case law or other public record advocates could access to see what legitimate business reasons are accepted?
Yeah, so that's a good question. So those legitimate business reasons, there is really no case law. There's only guidance. Those lists actually came from the HUD guidance on the ban on the use of conviction records, and that was, I believe, in 2016. I think those factors, and so it's called an individualized assessment, but I don't believe I know of any case law around that. It's just, these are just the guidelines that housing providers need to take a look at before they can exclude someone from housing. And so it's based on a case-by-case basis and an analysis, different factors.
Okay. All right, and then exclusion. So federally assisted housing are subject to federal regulations and require denial of tenancy for lifetime sex offender registration, conviction of methamphetamine production in public housing, rental housing where an owner occupies part of the unit, or an accessory dwelling unit or detached accessory dwelling unit where the owner maintains a permanent residence on the same lot. Sarah says, the Seattle Times did a story on November 19th, 2021 about how of 1,300 new housing choice vouchers that were given out in 2021, only 10 people were able to use their vouchers. Many landlords required tenants to make 4 times monthly rent. This did not account for the tenant portion of rent, but the entire rent. What enforcement action is SOCR able to take for the many voucher holders that are not able to secure housing?
Yeah, that's a great question. I think that's one of the struggles that we have, is that our laws is a complaint-based system, which means if an individual believes that they're being excluded because the landlord is not considering their housing choice vouchers or alternative sources of income, or if a landlord is not applying first in time principles or the law in any of those situations, they come and file a complaint. The challenge is a lot of people don't know that they're being discriminated, right? They don't know what their protections are and necessarily know who to go to when these situations happen. It's interesting with that article. I think it was, I can't remember, there was a group that actually had provided that information. I had reached out to them to get some clarification, because one of the things that we can do is do what is called the director's charge to investigate those complaints, but we didn't actually get any additional information about what their source was from this sort of information that they gathered. So yes, that is something that we are aware that these are some ongoing concerns, but the challenge that we have with our laws is that it is a complaint-based system, that we actually have to hear from the public if these situations are happening. And then we investigate it based on the information they provide to us.
All right, and then the last thing we're going to cover is the 2020 eviction records protections. So on May 10th, 2020, the Seattle City Council passed a new law which amends the Fair Chance Housing Ordinance 1409, which, prohibits landlords from taking an adverse action against a tenant based on eviction history occurring during or within 6 months after the end of the civil emergency proclaimed by Mayor Durkin on March 3rd, 2020. So now landlords cannot take adverse action because a tenant or potential tenant based on their COVID-19 related eviction history. This refers to any history from, like I just said, the civil emergency or for 6 months thereafter. This applies to all rental housing, including DADU, ADU, and single family dwellings. So what it does is it expands the definition of eviction history to include eviction court filings, insurance of eviction notice, issuing eviction notice, and any notification of intent to evict. It requires notices to prospective tenants to include the following language: the landlord is prohibited from taking adverse action based on the tenant. But I just read. It creates a rebuttal assumption that a landlord who sees a history has used in reaching an adverse decision, and it adds COVID-19 as a good cause for an order of limited dissemination, except for evictions that were based on imminent threat. So Mike, do you want to go over this slide?
Sure, happy to do so. So I know that there's a couple of questions, and some of you in the audience actually may have experience with our office, and happy to talk offline about what that experience is. But this is a step-by-step guide of kind of how to file a claim of discrimination with our office. The first step is to contact our office. You'll contact our office either by email, by phone, on the web, and be able to tell us a little bit about what the situation is, like what happened. And what we do is we follow up to make sure it's jurisdictional. So did it happen in Seattle? Did it happen within a year, which is our statute of limitations? Is it something that we cover? And the other question is, have you already filed with the Washington State Human Rights Commission or HUD or another agency? One of the things that we do is that if you already open up a discrimination complaint with HUD or the State Human Rights Commission, we will not open up a second claim because you've already have that being addressed in that by that agency. The second step is we schedule an intake meeting. And so with that intake meeting gets a little bit deeper into the who, what, when, where, why documentation. If it's a service animal case, we may need to have some information about your disability and disability related need for that particular accommodation or modification. We may need some emails, anything that evidence to really show that yes, this is something that we can take a look at and look at more closely. The more information that you gather and documentation you provide on the front end will be very helpful in terms of how we navigate and we address your complaint during the investigation process. Once we've gathered the information, the intake investigator will draft what is called a charge. That charge basically gives the authorization for the department, for the Office for Civil Rights, to investigate your claim. Once we have your signature that you are wanting us to investigate, we then notify the parties, the charging party, as well as the respondent or the housing provider, to provide us documentation. We conduct witness interviews. We conduct other information that we gather. We may contact medical providers if needed, other things to gather as much information as we can to either determine whether or not a discriminatory act has occurred. And then in step 5 are the possible outcomes. Once an investigation is completed, no reasonable cause means that the evidence does not support or show that a discrimination has occurred. I will say that discrimination is really difficult to prove. A lot of times, especially if it's a retaliation or harassment case, we're basically just gathering statements and whatever documents we can to be able to show whether this has happened or not. Reasonable cause is basically the other side of it, where there is evidence to believe or there's evidence to support that a discrimination violation has occurred. About 20 to 25% of our cases resolve through some sort of settlement or mediation process. We have a full-time mediator, which is an added position just earlier beginning last year and into this position. And we do have mediators who actually are trained to help resolve complaints of discrimination, try to find a quick and suitable remedy. An administrative closure is basically when the evidence where we find out during the course of investigation, we don't have jurisdiction or other types of things that would prohibit us from being able to continue the investigation. And next slide.
That's our contact information here. So both of our emails. And then for tenants, there's an email, discrimination@seattle.gov. That is, it's the same email for both, but that is a great way to reach us for more broad questions like that. And then I see 2 questions in the chat. So SOCR investigations can take months to reach findings. Can SOCR do anything to act promptly if there is a denial of housing based on evictions taking place 6 months after the eviction moratorium?
Yeah, that's a very common question. Our investigations take anywhere between 180 to 300 days to investigate a complaint. We currently have over 100 discrimination complaints not just in housing, but also employment and public accommodations. And we've also had a significant turnover in staff, which has made it really difficult to stay on top of being able to address those complaints in a timely manner. But in terms of actions, the only thing that we can do is because we aren't able to take any sort of action until an investigation has been completed. And so that is one of the limitations of our process, is that even though we investigate cases free of charge, we provide interpreters, reasonable accommodation, and other services to individuals who need assistance. Unfortunately, there are some limitations of what our laws allow. Really, the only way to take quick action is to file it in court. A judge can take much more speedy responses where you file a complaint with the court, and then they have to respond, and then the judge can make a decision at that point whether to stop an eviction proceeding or any other sorts of action. So those are some things to just to kind of be aware of, some of the limitations of our office, but then also the discrimination complaints that you file can easily be addressed with the Housing Justice Project. You can talk to your attorney advocate to say, hey, we want to not just file for wrongful eviction, but also discrimination or failure to provide reasonable accommodation. Your advocate, your attorney from Housing Justice Project can assert other fair housing protections in that forum, and you may be able to get a response much faster.
The next question, just to be clear, we're still in that civil emergency, correct?
That is correct. Yeah, so that has not been lifted by the current administration.
So what percentage of complaints does your office take action?
In terms of what percentage that we find reasonable cause, is that my understanding of that question?
I wonder if that's from intake. Do we have that? From maybe do you have both of the answers? Yeah.
In terms of question, I guess, for the audience, and hopefully they can put it in the chat or just come off mute too. I'm happy to have a further conversation. Are you talking about in the course of an investigation when it's completed, how many cases where we actually find reasonable cause and take action? Is that the question? Well, I'll go ahead and answer that. And hopefully it is a question. So about 5 to 10% of our cases, we do find reasonable cause. So we do find that there's been a violation by the housing provider or landlord, that they have violated the fair housing laws that we enforce. I will say that about 20 to 30% of the cases we resolve through early resolution, whether it's mediation, conciliation, where the parties have come together and say, hey, you know what, we're going to address this issue and we're going to resolve it either during the investigation or with the mediator directly. And so about that percentage, I would say about 10% of the cases closed by administratively, where the parties, we just decided we don't want to continue this investigation and so forth. And about 50%, the remaining, is cases where we find no reasonable cause. So there's not enough evidence to show a discrimination has occurred.
All right, and the last question is there a state law equivalent to the denial of housing based on evictions taking place in the last 6 months after the civil emergency? Good cause grounds for an OLD?
I'm not sure about that. I can ask my colleagues over at the Seattle Department of Construction and Inspection. That department handles a lot of wrongful termination or evictions or failure to pay rent or other sort of code compliance. That if you go to Renting in Seattle, which is run by the Seattle Department of Construction and Inspection, they can provide you that information about eviction protection, not just in Seattle, but also statewide.
That was all the questions in the chat. Does anyone have any other questions? Feel free to come off mute or use the chat.
I have a question. I think maybe I'm just looking for a confirmation, but something that we've recently realized with the complaint-based system with SDCI for enforcing renter protections, of which we have more than most cities, is that there's no real, as far as I can tell, incentive for landlords to familiarize themselves with the actual laws. There's not like an actual major punishment, and unless it's something extremely egregious, it's usually mediated. Often over the course of a long time. I know that SDCI said it took them 42.3 days on average after their inspection to resolve the issue. And I'm wondering if that's a similar situation with the Seattle Office for Civil Rights, in that there's not like a very clear like punishment for a violation. It has to go through court. Is that generally how that works? I just wanted to, it's not a criticism as much as just a question.
No, that's a fair question. I think that's one of the challenges that we have as an administrative agency. This is one thing that you'll find when some of the challenges, not just on the local level, but state level and the federal level. When you have three branches of government, right? You have the executive branch, you have the legislative branch, you have the judicial branch. And we are part of the executive branch of government, which means that we have kind of a quasi-governmental responsibility to enforce the laws that we do, right? We also have a responsibility to do some sort of rulemaking, right, on those things. And then we also have a judicial element of investigating these cases. But how the division of government works is that it's the judicial branch that has the final say. So even if in a situation, Kate, where even if and this has happened before, where we have found discrimination in our investigation, but we go to the hearing examiner or goes to the district court judge, and they will say no. They look at the case kind of in a brand new situation. They'll take a look at the records, and they can make an independent decision separate from our administrative decision. And that's just kind of how our system kind of works within our government framework. The other challenge that we have between the laws we enforce versus SDCI is that SDCI enforces more code-based, right? It's either you have a working stove or you don't, right? You have hot water or you don't. You have electricity or you don't. Discrimination is not like that. We know that most times in discrimination, we don't find housing providers says, hey, I discriminate against people with a different gender. I discriminate against people with disability. You don't get people. A lot of times discrimination is becoming much more underground, right? It's definitely not the same as it used to be pre-1960s. So I think that is what has made challenges. And when we're balancing the facts, it's their words against your words, right? Who knows what the person is actually thinking, right? They say, hey, I really like you, but in the back of their mind, they may be thinking, we would never consider renting to you because of a protected class. And those are the realities of just the human nature and the challenges with civil rights. The other thing about it is that sometimes we don't address the structure, the structural challenges in the system, right? I think people had provided examples of structural forms of discrimination, like credit reporting, policies and practices, Social Security. All of those are rooted in very structural and institutional impacts that prevent people from getting equal access to housing. And it has a disparate impact on protected classes. So I don't know if I answered your question, Kate, but it's a good question, but it's a hard question.
You did answer it. I think just for us as tenant advocates, it's frustrating when, we go through all of the right systems and then you find out that well, they're just going to tell the landlord that they're not supposed to do that. But that certainly that's more a criticism on our whole broad system than anything.
Yeah.
And I saw there was one more question here in the chat. It was Diane was following up to an earlier question. If I file a complaint with your office, will HUD or the State Office of Human Rights not accept my complaint?
Yes, that is correct. The only time that they may accept it if it's a different protected class that's not covered under the city ordinance. The city of Seattle, however, has the most protected classes in the country. And so whatever we take is likely that it's covered. You just remember under the Federal Fair Housing Act, there's very limited protected classes that they will look at, and it's race, color, national origin, disability, familial status. They look at sex and religion. So they have only about 7 protected classes versus about 20 that we have in the city. The state level is about 16 or 18. So they have a fewer set of protected classes. But typically they won't accept it. Yeah.
Thank you for clarifying that. I guess I have a follow-up to that. Where would somebody generally start if they have a complaint, if they have these several options? Who has the most power or speed?
Yeah, I just know that, talking to my colleagues at the State Human Rights Commission, I know that they have a significant backlog of cases. And so if you're looking for speed, it's probably to contact our office. You'll probably get a quicker response time. The Housing and Urban Development, which they have an office here in downtown Seattle, they also have a significant backlog of cases. A lot of times, if they take a case, they actually assign it to the Washington State Human Rights Commission to investigate. So it's kind of like that sort of telephone loop that sometimes happens versus just talking directly to our office. I mean, the other thing about our office is that we're here to help to answer questions. So even if you're not sure whether this is discrimination, we're a resource to just talk through kind of what is it that you're experiencing and come up with some solutions and ideas of how to address those particular issues. So just because you contact our office doesn't mean we're going to investigate your case, but we want to make sure that we're meeting your needs and we're listening to you, meeting your needs and answering questions that you have about our process and about the laws that we enforce.
That was very thorough. Thank you. That really illuminated that for me. Did anyone else have any other questions for, I see, Diane, you have your hand raised. Go ahead, right ahead.
Hi, thanks. Yes. So if I file a complaint with the Seattle Department of Construction and Inspections, will that also mean that I can't file a complaint with you?
No. So the Seattle Department, that's a great question, Diane. That's the Seattle Department of Construction and Inspection. They enforce the tenant protections. So the Landlord-Tenant Act, anything that's, that really defines whether someone gets the move-in expenses or fees and things like that. we protect things where individuals are being discriminated based on a protected class. And so you can file with the Seattle Department of Construction and Inspection and file with our office. There are cases sometimes we work closely on the same issues. It's the same issues, but one is violation of the tenant protection and one is the violation of fair housing. And so, yes, we encourage you to contact both departments if you need to address your needs or your concerns.
All righty. Well, thank you both so much for that fantastic presentation. And I think we will all be reaching out to your office with more questions, but we really appreciate your time tonight. And so I wanted to move on to our final speaker for the evening, Devin Glazer. Devin is a staff attorney at the Tenant Law Center, where he provides legal assistance to tenants facing eviction or in ongoing disputes with their landlords. The Tenant Law Center provides free legal assistance to low-income tenants throughout Seattle and King County. All right, go right ahead, Devin.
All right, and forgive me, I don't have a PowerPoint to go along with, so that gives me more room to potentially ramble, and also just hopefully lets me kind of go back and forth. So I also at some point want to just open it up to any questions or otherwise kind of create a dialogue, because that's easier. So I work for the Tenant Law Center. We provide tenant defense to people facing eviction, both in Seattle and throughout King County. In the wake of COVID-19, what we've shown, what's been done, we finally started to create like a safety net to protect tenants and help them provide legal education when they need it. It's still not sufficient, right? I think that a lot of what the underlying, like that presentation was amazing. So thank you so much. And also I think what it showcases is that we have these protections. Many of them are written out in paper and it's really hard to enforce them. And I can say as a staff attorney, it's hard to enforce them, even with a bar license and the loose ability to sue and litigate over these things. There's just a lot of injustice that's happening and not a really easy way to defend your rights. I say that not to demobilize you. I say that actually more to mobilize you and say, you can fix that, right? Like we can fix that. Like these are not, stone tablets coming down from the sky. These are the laws that we all come together and pass. And so I think the city of Seattle has done a pretty good job of creating basic protection, saying, if you have rental debt from COVID that can't be used against you, if you're being discriminated against based off this slew of protected classes that are worthwhile, you have some rights, but they're all paper rights until we demand strong enforcement, right? And that's not to say that, my allies working in the Seattle Office of Civil Rights are not doing a lot of work. It's that there's just so much going on. And we do have, a fundamentally unjust world. I'm glad we started this both with land acknowledgement and then focusing on the history of redlining in Seattle, because that same discriminatory policies and discriminatory land decisions trickles down into our day-to-day, who has wealth, who owns the house, who is a renter, who is being disproportionately impacted by rent increases in Seattle, everything else. Kind of along that line of some really great laws we have, the state passed a just cause allowing us to, you have a right to renew your lease. So if you're in a dispute with your landlord, they can't just kick you out. And then the city has extended that right to even kind of fully flesh out those defenses. But then we don't have rent control. And so you can win all of these claims and say that my landlord's retaliating, I need to have a service animal, I'm being discriminated against. And 6 months later, a year later, your landlord can raise your rent to the point that you're out anyway. And it's really frustrating because, again, we have these rights and we know that they're there. And then the loopholes in them, the gaps in them, the things that we still need to advocate for mean that eventually you kind of don't have, you don't really have that right, or you have it as a short-term fix in between a much bigger problem. So most of what we do at the Tenant Law Center is work with people who have COVID-related debt. There's no longer eviction moratoriums, but there is a lot of procedural requirements before someone can start an eviction case against someone just for back debt. And so we're helping people work with the landlords, find access to potentially rental assistance, get on repayment plans, But we've made a policy decision. This is again, the goal to mobilize people, that landlords will basically be made whole and tenants will be paying, normal rent plus extra until they can catch up on what they owe. And that was a choice, right? Like the governor said, workers couldn't go to work for a year, right? The governor said renters couldn't make the income they needed to pay rent. And then we've said, but landlords will get their money eventually. So there's a lot of work to do. That does not mean that you don't have your rights. And it tends to mean that if you feel like your rights are being violated, you're right. Like your rights probably are being violated. But we need to find ways to connect tenants to power so that they can further defend those rights. And I say that as someone who can go to court and sue someone, and I can still say that that's not enough. That's all I do really at the end of the day is read the laws that we decide to pass together as a society, and the laws that we have already passed as a society are insufficient. So on that really charming note, I would say be fearless. Like we do have a lot of protections. And so if your landlord is retaliating against you, if your landlord is trying to make your life miserable, that's the time to really stand up for your rights. And there are people who you can reach out to like help you advocate for yourself. But then also be tireless because one, there's a lot of people who have similar issues. And then two, like you're going to have to do a lot of work yourself because there's not a robust safety net that can carry you across, the finish line. There's a lot of injustice happening, across the world and here in Seattle, and it can be exhausting. But we're here as a resource. If people have questions regarding landlord tenant, we're really happy to at least spend 20, 30 minutes walking you through what we think your rights are and what we think the solution is. But it often is not going to court. That is both a slow process, an expensive process, and at the end of the day, you probably don't get the outcome you're hoping for. You kind of end up more with, I don't know. It can be a bad outcome sometimes. So I guess with that, I'd love to have a dialogue and kind of answer some questions and move forward. Just because I don't know, that's all I have pre-prepared. But I'm here to talk to people if they have questions about landlord-tenant law or their rights or et cetera.
It's more of a comment, but I wanted to note that you said like there's a lot of other people who are experiencing similar things, and that's kind of like the main purpose of these building tenant power workshops is to draw attention. Like first, know your rights so you know how to insert them, and that was with the Seattle Office for Civil Rights gave us this really thorough presentation where now we know what's protected and we know what's not, and maybe what we're still suffering with. And sometimes we do have to lobby and find these gaps where we can work together. And so you pointed out so many good ones where bringing someone to court is not the ideal solution. But if you're not the only person experiencing it, if your neighbors are experiencing it, these are opportunities for organizing. And we haven't really talked about the fact that like the just following the existing laws, it's not all we can do. There's certainly ways to pressure landlords to make changes, to treat tenants with respect. These are great opportunities for building organizing, for lobbying, building tenant power. And then the other thing before I forget is that we haven't really addressed zoning, and this isn't a zoning workshop at all, but when we looked at the redlining guides, where there were the racial covenants, Seattle's neighborhood residential zoning isn't allegedly racially based, but it certainly looks very similar to how it looked 50, 60 years ago. And so zoning is impacted. How many times lost the way I wanted to phrase that? We need to fight for these changes to make these neighborhoods more accessible and equitable to everyone.
Yeah, I grew up in North Seattle, and it was a very white community of a whole lot of retirees. And my mother is still there. When I visit, it hasn't changed. I live in South Seattle, and it's actively changing, which is what happens when your city grows. And then I go back, to where the city I grew up on, the house is the same. The house my mom lives in is the same. Like the trees are the same. And there's no poor people there because you just can't afford to be there. And there's also very few, if none, like no people of color, because those same red lines are still there. They're just now economic. And so, yeah, I think that's a huge component of it there. And then like if you parents owned this property, now it's $1 million property, and they can use that to help their kids buy a second house in a way that is not available if your parents were discriminated against one generation ago, right? Like, I mean, and this current generation really. So I think that, if you look at the Transit Renters Union and the Stay House, Stay Healthy Coalition has done some really good like data, I don't know, analyzing just to showcase like who is most impacted by rent increases. And it's like, we're seeing like tenants of color are seeing higher rent increases than white tenants. We're seeing women are seeing higher rent increases than even male tenants. Whether that is, I mean, like, we don't know why. It's clearly discriminatory in some form or another. Why it's happening is always kind of the hard thing to prove, at the end of the day. But that impact is going to be more displacement of people of color and more displacement of women and, not men. And I don't really want to live in a city that's all like rich white dudes, right? And like, that's not anything against rich white dudes, but like, that's not a city, right? That's a workplace in a tech suburb or something. So these are things we need to work on. And part of that is making sure there's enough housing. Part of that's making sure that people currently staying, who have a home are not displaced. And then part of that's making sure that people who own land and own a second house and can rent it out are not discriminating. There's a lot of discretion right now in the rental market, and that discretion allows for a lot of bias. I was agreeing with you. One of the things I really like is the first in time rental applications, because you can't say in advance, I'm not going to let you in because I just don't like your vibes. And so that's one way to eliminate bias. But I mean, with what we can charge for rent, again, we need some way to control these rents, right? There's a lot of bias that comes in there, because your landlord, if they like you, they can raise your rent 5%, 0%, or 100%, right? I've seen a lot of fees kind of come into play over the last few years in response to some extent to just cause protections. Landlords will apply these fees and then waive them if they like what you've been doing, or if you're a good tenant. That's another area where because we allow discretion, we allow for a lot of bias to creep in. People who are behind on rent, it's up to the landlord to accept a repayment plan. And I mean, this is now anecdotal, but like, I noticed that my white tenants are getting better deals than my black tenants, right? Like, there's just a lot of bias in the system, and we have a power imbalance and discretion, and it leads to negative outcomes. And so these are things we should try to fix, right? Like, we shouldn't accept this as a status quo.
Yes, absolutely. I think I mentioned in the chat that I just recently moved, and while I was looking for places, I went and talked to a small landlord who seemed just so unaware of any of our current like discrimination laws, and was just pretty blatant about it. When she was shocked when I told her about the first in time law, she just wanted to have somebody move in that she liked. And so really asserting our knowledge of these laws is just so important, and it's important that landlords are aware of them and are aware that we know.
Yeah. Well, actually, and we've kind of gone back and forth some, but I've now heard 2 incidences of people who were advertised one rental price and then applied, and then once they got the place, the rent went up. And they ended up just signing the contract anyway, because there's so few apartments available. There's not a lot of room to play like, oh no, you didn't, like, I want my money back type like games. You're like, okay, I take this bad deal. But the county has actually made it illegal. They've done a ban on unfair or deceptive practices in the law. That's the type of thing that I think if Seattle were to also pass, we could say, if you advertise one rent and then change the rent once you've gone through, like, that's a violation of this. But that area only covers unincorporated King County right now. And I think Kenmore is going to also adopt the same laws. So there's a lot of small tweaks we can do. There's a lot of gigantic tweaks we need to do. And we should all be advocating for all of them, because everyone deserves a home. And right now, home ownership is so heavily privileged in the society, and renting is so disproportionately, like, I'm losing the word, but like the opposite of privilege, right? Like, it sucks to be a renter, and it shouldn't, right? We allow wealthy people to buy rent control in a 30-year mortgage. And then if you are not rich enough to afford a down payment, your rent just kind of goes up with the market. And that's horrible. And like, if we speak of disparate impacts, that's a very disparate impact, but it's really hard for us, based on the current interpretation of laws and the current interpretation of the Constitution, to use that against landlords. But it's leading to a lot of really horrible outcomes.
I realize that you and I kind of just got into this, but does anyone else have any questions for Devin?
Yes, I have a question. Can
Go
you
right
hear
ahead.
me? Hi, I'm Diane.
Hey, Diane. It's been a while.
I know, it's good to see you.
Yeah.
So I've been advocating for seniors, as in elders, for over a decade, and even more now that I'm in affordable senior housing. And I've been in 2 different affordable senior housing, and I'm talking about real affordable, not the 1,015, 2,000 a month like Shag. I'm talking about HUD housing, and that I've had 2 experiences where my health and safety have been extremely harmed, and that my life has been at risk, and not being able to get help from the people in power. And in my decade, more than a decade of advocating for seniors, most politicians, most advocates, seniors aren't even mentioned. And what I've learned living in senior housing is that most seniors have no other choice once we get into affordable senior housing. It's like being trapped, because there's a mountain of paperwork to get in and qualify for it. And then most of us don't have family or any place else to go, and we certainly can't afford market rents. So feel trapped, and most seniors are afraid to speak up. So tenant organizing, that's out. So I've been on my own doing all that fearless, tireless, exhausted work. And so I'm getting ready to do the complaints with SDCI and et cetera, which is each one of those are overwhelming. So does your office help with things like that at all? Because it's what I'm hearing a lot is the general rental market, all the issues around that. But I rarely hear anybody talk about age discrimination, ageism. And it's not just about building housing units for people to live in. We see all the politicians bragging, doing the photo ops in front of new buildings. But once we get put into a building, health and safety is so important, but it's being ignored. So I know that's a long background. So basically the last place I was in was SHA, and there was cigarette smoke, massive cigarette smoke coming into my apartment from the guy next door. And I moved out of there into a new place, and this place is completely infested with bugs, biting bugs. So I haven't been able to get help at either. And what I've experienced is the people in power in both organizations ignoring and lying about it and doing nothing to help the seniors. And I know I'm not alone. I know there's other, and it's predominantly women, because the women of my generation stayed home and raised kids for free and don't have the big pensions and Social Security and all that. So it's mostly senior women that are lower income, and of every race. My building that I'm in now is every race. The building I was in before was every race, but it's mostly women. So is there any help, any suggestions you have for that?
I mean, I think SDCI is probably a good place to start. We can always call at some point the Tenant Law Center. We can try to figure out this unique stuff that I don't want to like put all your history, in the public chat. But I mean, honestly, I talk to a lot of elders who don't have housing options, right? Like their Social Security or disability is X amount, their rent is now more than X amount. And it's a really hard conversation I have repeatedly where I say, do you have friends? Do you have family? Do you have, a church? Because there's not a guaranteed safety net. And so I don't say that because I like that is the status quo. But we have not decided to take care of our own, right? Like regardless of whether you're a young person who can't afford rent, or particularly if you're an old person on retirement and you can't afford rent. And so I'm going to say that just more to say your story is, I mean, it resounds with me. It resonates with me. Like it sounds very truthful. And so yeah, in Seattle, I would start with SDCI, and we can certainly, again, try to talk longer and figure out, better options. But you're not alone. There are a lot of people who are not able to keep up with this, fun rising housing market here. But we should all stay in the communities we are part of, right? If you're part of Seattle, you deserve to stay regardless of whether or not you're a wealthy, Amazon. The Seattle Department of Construction and Inspections, SDCI. Sorry, we get so caught up in our acronyms. I just saw that in the chat. But yeah, even if you are in low-income housing or income-restricted housing, you still have all these protections. You still should be guaranteed a safe house. You still should not have bed bugs. You still should not have neighbors threatening your life. Like, those are things that you do deserve. And the problem is we don't have strong enforcement mechanisms. We have lots of places to kind of try, but they're not necessarily. I mean, there's not enough, right? Like, that is truthful.
I also wanted to add, Diane, that Seattle is facilitating our elder renter council. We just started. We're working on our values statement at our next meeting. These are the types of issues that you're right, a ton of seniors are experiencing. And we have our board member, Dolores, is a part of that council, and she has a lot of experience dealing with this and can certainly help walk you through these types of things too. If you just want some peer-to-peer support and some solidarity, please consider joining us. We meet on the third Wednesday of every month at the Capitol Hill Library from 12:30 to 2:30.
Will there be any evening meetings of that council? Because I am very interested in participating.
Currently, we don't have any scheduled, but if we get some more folks interested who would prefer to do evenings, I have the flexibility to facilitate that. That was just kind of the agreed upon time of the folks who showed up. It seemed to work for most people, but we're not stuck to those particular times.
And will there be any Zoom, and will there be any email lists with information about what you talked about? Because I signed up for that, but I haven't seen, and I wasn't able to attend because it was earlier in the day. But I would like to know what's happening with that. Is there any info? Is there an email list to get on or anything?
I can make sure that you're on our email list. I just got it set up a couple days ago. I haven't even sent a follow-up email from the last workshop or from the last council meeting, but yes, I will make sure that you're on there and you are included.
Thank you, because I'm very interested in that. Yeah.
And also, again, with the peer-to-peer support, I'm sorry, Dolores, for putting you on the spot, but you told me when we started this council that you wanted people to reach out to you. So let me just put Dolores's email in the chat too.
Cool. It looks like actually Jay McKay is saying, please repeat the library times and day. What time is that again?
Actually,
it is
Dolores, and we'd love to have you. Absolutely. It is 12:30 to 2 at the Capitol Hill Library. July 20th, right?
Yeah, I think we decided 12:30 to 2:30.
Okay.
With a goal to try to end within 90 minutes, but folks got chatty. But it's going to be on the third Wednesday of every month. So that is the time we have blocked off for now. But if we get a bunch of people who would prefer evenings, definitely we can discuss rescheduling. And then Dolores's email is right there in the chat if you want to schedule a one-on-one conversation with her, or I can also join.
Yeah, and the other thing is Zoom is a good idea, because seniors, of course, aren't always, they can't always just drive right there. So,
well, also there's a lot of seniors like me, even though I've had 4 vaccinations, I'm still worried. Every day I see like 5 new friends that got COVID, so I'm still afraid to go in person.
I just recovered from COVID myself. It was very miserable. I would not recommend it. So, and I'm still coughing for some reason. So,
and there will be a regular email update, because we're just getting started now, so we're setting all that up.
Excellent.
And I guess
Thank you.
just curious, what's the age requirement or threshold for being considered a senior?
I mean, so everyone is welcome, but we're kind of focusing on folks who are 55 plus. But we had someone who was a few years under attend, and it's not a hard limit.
We're not carding.
Yeah, we just understand that there are some issues that are kind of unique to the elder community, and we want to make sure that there is plenty of space for them because they're often ignored in organizing conversations.
And since we're seniors, we're too wise to discriminate.
Good.
That's funny.
So if you're interested in senior issues, absolutely come. We welcome you.
Yes, and with regards to the Zoom meetings, we initially decided to do them in person because there is a bit of a technology gap with some of the senior community, although it is narrowed quite a bit because of COVID, and a lot more folks are able to use Zoom and things like that. So I
think that's a
workshop.
myth because I'm in AA meetings every night on Zoom, and there's lots of old folks like me.
I don't want to throw my mom under the bus, but I tried to teach her Zoom, and it was rough. I mean, she learned, but okay. We
Well,
are
it's hard.
almost
Just,
out of time.
one more plug. There's not enough, A, affordable internet options, and B, just like access to devices. So if someone wants to create a nonprofit about that, they should. But also, that means that people who are probably more likely to face eviction or otherwise have an issue are probably also not able to use, the courts right now are all via Zoom. We use a Zoom mediation center. We need to also make sure that we're planning as we have these resources for people that there are analog versions of them, even though that I like the Zoom option too.
Yes, and these are all conversations that we can decide collectively as a council as to what is most efficient and safest for the largest majority of people. Like I said, we just got started. We've only had one meeting. So we are running just a little bit short on time. So I want to thank everyone for attending tonight, and thank you so much to our speakers from the Seattle Office of for Civil Rights, and of course Devin from the Tenant Law Center. We so appreciate your time. So we have an action for tonight, and actually I added a second action last minute after this conversation with Devin. Sorry, let me hop back in. Oop, I lost my spot. Okay, so the first action that we have is donate to the Lavender Rights Project this month in honor of Pride Month. We're asking everyone to consider making a meaningful donation to the Lavender Rights Project. They're a Black-led, queer-led organization that elevates the power, autonomy, and leadership of the Black, intersex, and gender diverse community through intersectional legal and social services. You can check them out at lavenderrightsproject.org. And then the second action just added, email Seattle City Council and ask them to expand our renter protections to ban unfair or deceptive practices with regards to housing. You could specifically cite that landlords have been doing this bait and switch where the tenant fills in an application for a rent at a certain amount, and then when they sign the lease, the rent has been increased. Devin said that he's run into a couple cases of this, and I actually just contacted him about a tenant who emailed me about this, and they were low income, so of course they signed right away because they were afraid to lose the spot. It's pretty common, and since King County is banded, the city of Kenmore is soon going to pass the same. This would be something great for Seattle renters. And so that was
or anything else.